Welcome to the court gallery. This is the stunning conclusion of our pro se trial disaster. Here we will witness the self-represented defendant take the stand to testify in his own defense, and it immediately goes off the rails. Instead of discussing the facts of the case, he launches into a bizarre narrative filled with constitutional word salad, complaints about his mail, and wild conspiracy theories against the entire justice system. The judge repeatedly warns him to stay on topic and stop interrupting, eventually threatening to throw him in a holding cell. But this guy just thinks the world needs to change, not him. You'll see. It all starts right now.
Okay, ready? Come on in. And we now recall clause number 23 CR 727, the state of Texas versus Raymond Peoples. The defendant is present, the state's present, and is the jury ready? Kendall.
We'll get checked it.
Thank you. Record shall now show that the jury is present and seated in the courtroom. Ladies and gentlemen, we had to take some matters up so that we could finish all of that and then focus today on this trial. So we're not going to get interrupted again. We were able to take care of all that business. So we're going to pick up where we left off here. The state was presenting its case in chief by calling witnesses, and the state may call your next witness.
Oh, let's take the rest, John.
You're up. What do you want to do?
Yeah. Well, I mean, of course, you're not going to, if I ask you to be a witness, of course, you're not going to do that, correct?
You were supposed to do that
I want to
when you represented yourself. That's what they do. And I asked you, get some help, and you refused it. They're the ones who know how to do it. You don't do it in the middle of the trial, sir. These people have work, things to do. You're supposed to be prepared. You said you were ready. You insisted on moving forward. But we can talk about this at the lunch hour. Is there anything you want to bring up other than, did
testify?
you do?
Yeah.
All right. You may call yourself and come forward.
Call myself.
Yes, sir. Have a seat, please. Raise your right hand. Do you solemnly swear or affirm any statement you make during this trial will be the truth, the whole truth, and nothing but the truth? So help you God.
God.
Lower your hand, please. Please sit, be seated. Ladies and gentlemen, when a person wants to represent themselves and make testimony, we don't have anything built into the system where we play like a question is being answered. And this is question and answer. This method, when a defendant wants to represent themselves, it's different altogether. And this is the exception to the rule. He may make a presentation, an oral narrative, and then when that is completed, then the state gets to cross-examine. But it's not a question and answer. In this particular case, when a defendant insists on representing themselves and testifying, they get to make a narrative statement, and they're going to be held to the rules that it needs to be relevant. It's to the allegations at issue in the four corners of the indictment. All right. You're on the stand. You've been sworn in, Mr. Peebles, and you may go forward. Thank you.
I'm a 37-year-old man, born in 1988. I moved to Texas when I was 18 years old. I was born and raised in Detroit, Michigan. I have I have 4 children, 3 boys and a girl. The first time I've ever been charged with a crime was when I was 27 years old. I am I work out. Um, I'm I'm healthy. My health is in great shape. So if I start shaking, foaming at the mouth, looking as though I'm having a seizure, which I've never had in my life, it's because you're talking about something that you don't want me to talk about. And they are electrocuting me through this shock box that they got on my leg. They are electrocuting me through the shock box that they got on my leg because they don't want me to talk about the prior cases and why I'm in here and all the stuff that they've been doing to me since I've been incarcerated. Yes. Yeah, I'm very scared right now. You know, all my kids are watching this because I told their mothers to make sure they don't go to YouTube and watch this. And one of them 15, one of them 14, one of them 11, one of them 4. I'm disappointed in time and time again because they thought I was coming home so many times. I thought I was coming home. But because I'm outnumbered by the government, and there's so many powerful people in the government that hate my guts, not because of what I did to them, but because of who I am. When I got arrested, I was working with Nighthawk. It was contracted with several different plants. We did environmental survey. I was working with them for about 2 years, very consistent. I also started working back in my old job at an arcade for kids. So I was working 2 jobs, and I was still able to make a lot of time for my children and my wife. I don't understand why these people want to keep me incarcerated so bad. I have filed numerous affidavits throughout the years telling them that I wouldn't file a lawsuit. They just let me go home. But I'm not about to sign for nothing because if I do, I won't be able to get my job. That signing for anything is not enough. I've never been convicted of an extraneous crime before, and I'm not about to start now. I was a law-abiding citizen. I did 7 years of my life fighting for people in places that they know I didn't do. So yes, I'm about to talk about every single factor from the day I was charged with the first illegal crime back in 2016, all the way up into this new crime that he just told me about of some feces being thrown on somebody. And everything that I'm about to mention is on record, or I have witnesses about. And I'm about to educate the jury about the law that y'all keep breaking, about the rules that y'all keep breaking, and how y'all like to keep trying to manipulate stuff to keep me in here. They talk as if they don't got a personal problem with me. This is my fourth trial. My fourth trial. And the only time they was able to get a conviction was when it wasn't a jury in front of me. And that conviction came from a probation violation of a charge that they had no jurisdiction over in the first place. It was supposed to be in misdemeanor court, not felony court. $7 years. Yes, I'm about to exploit all this evidence. So I want to start by saying, I want to start by talking about this partial jury trial that's going on right now. It's completely unfair jury trials that they forcing me to go through right now. Doing a jury selection 2 days ago. And then 30 minutes into it, the judge don't sit up here and say, well, you need to make sure you ask the questions right and do all of this, because when the lady start transcribing this, she's gonna need to. And it was 30 minutes into it. I said, y'all not transcribing this? We're about to.
Hold on, sir. Sir.
What?
Sir, let's get relevant here. You were charged with the first-degree felony of aggravated assault against a public servant. This isn't the time to make a speech of your whole life. Let's stay within the relevant allegation. And don't interrupt the court. I've said, how many times have I said that? You have a fair opportunity to be heard. The court is required by law to direct the law to the people, and the jurors are instructed. We are focusing the relevant matters of the accusation in the four corners of this indictment. Let's stay within this. This isn't time for your life story. If you are found guilty, if we go to the punishment phase, there are matters you can bring up that are relevant to punishment. This is only about the allegation. Please stay within the four corners of the charge. Thank you, sir.
The jury, the day I'm talking about is the jury selection for this charge. So
Stay within the four corners of the charge in this indictment. That's what's relevant. Thank you for following the rules.
that's what I'm doing. So there was no point in me objecting to what I was seeing on the jury selection paper, because he wasn't.
Once again, sir, this is with the four corners of what happened on or about June 6, 2023. Let's don't talk about jury selection. This was all, that's not relevant to the facts. Stay within the facts, sir. Please go forward.
The Sixth Amendment says the accused shall enjoy a speedy public trial by an impartial jury. The word impartial means fair. In the district, whereas the crime shall have been committed, which shall have been previously ascertained by law, shall be confronted by the witnesses against him, which means the witness that's against me shall have said that I did whatever they charged me with. And yesterday, that man sat right here and said, yeah, you scratched me. That's how I got my injury. He sat right here after we read out, the victim sat right here after we read out his report. And he said that his report was accurate. And he said, yeah, after he got done lying and perjuring, he couldn't help himself. He had to, you scratched me. That's how I got my injury. But yet I am indicted for stabbing him with ink pen. And you talking about standing before preach. That's exactly what I'm doing. The four corners, matter of fact, all persons born or neutralized in the United States.
Naturalized, sir.
Naturalized, thanks for correcting me. You're right. Naturalized in the United States. Ooh, you know this. And you know it.
Sir,
Okay,
just
sorry,
please
let me
move
finish.
forward with
All
what you need to say.
born or
Thank you.
naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. No state shall make or enforce any law, which shall abridge the privileges and immunity of the citizens of the United States. Last I checked, I was born in the United States. Nor shall any state deprive any person of life, liberty, or property without due process. Last I checked, me talking about how unfair a jury is, I had the right to do that because my right is being abridged. So I can tell the world and explain how my rights are being abridged during my testimony in the four corners of the indictment. Is that correct, Judge?
Sir, move forward and stay relevant to what the allegations are in the four corners. And please, for the 20th time, please don't speak over the court when I'm speaking. Sir, how many times have I said that to you? You have a fair opportunity to speak, but it's not on your terms. The law has its rulings. The rules of evidence have its rules, and you, in representing yourself, must follow them, whether you like it or not. You have to stay within the rules. It's just not a full-blown part where you have just anything to say without any restrictions. That's the way the rules were built. And you have to follow the rules and stay within the four corners. And this is what are the facts are that is alleged of wrongdoing in this indictment. Please speak to that. This is your opportunity. Go forward. Stay relevant.
Yes, Your Honor.
Move forward, sir.
I would like you to let me know if what I just said was correct or not.
It wasn't relevant to whether the facts are, I give the law. You don't start quoting constitutional law. I'm going to give the law, sir. You just talk about the facts. Please move forward. These people have valuable time here. Let's stay within the rules. Give them what your version of the facts of this incident were. Please move forward. That's what we're here for.
So you above the laws of this country? I'm just asking
you. One more statement like that, and I must hold you in contempt of court. I don't want to do that. I've ordered you to follow the rules. Please follow the rules. Direct the attention of the jurors to the facts as you want to say them in this allegation. Thank you.
Nor shall any person be denied within the jurisdiction.
I give the law, not you, sir. Just talk about the facts of this case.
Equal protection of the law.
You're not going to follow the directions of the court and the rules? Or
I see how Jesus should.
That's your statement?
I'm testifying on.
To the facts of the case, sir.
So you tell me I can't be a character witness to myself?
Sir, give what you want to say to the jury of the facts within the allegations. That's what we're here for.
The jury is sanctioned by law.
I'm sorry, sir. This isn't a debate. Go into the facts of the case, please. Okay. I've made a ruling. Follow the ruling.
I'm being a character witness. Can I call myself as a character witness?
You don't do it that way. You can speak.
Can I talk about myself?
Yes, you
character witness.
The character as to character is not relevant at the guilt or innocence phase. It's at the punishment phase. You can talk about what the facts are and what might have been motivations. I'm helping you out on this. You might have been what motivations that you had in acting within the allegations here. I can't tell you what to say, but character evidence is something that is reserved for the punishment phase, where the jury is to decide what the punishment should be. Right here, it's to determine, did you or did you not commit the offense? Not, are you a good person or not? It's about the facts of whether the allegations have been proven true beyond a reasonable doubt. That's the rule. Please stay within that rule. Go forward.
So the DA can destroy my case.
Go forward, sir. They can ask you questions on cross-examination, and you have an opportunity to do redirect statements on your own later. That's the law. You should know that.
For the last 2 days, you've been destroying my character.
Well, sir, that's,
I can't rebuild it.
you should have objected.
I did object. You told me that didn't make it. I did.
Okay, move forward. Move forward, sir. Speak on the facts of the case, sir.
I would like to object to the jury selection,
Overruled. Go to the facts of the case, sir.
but I need to
Sir, it's overruled.
before you.
Sir, it's overruled.
Okay.
You move forward and we'll take,
on record.
I'm sorry, sir, we'll take that up outside the presence of the jury and you'll have a fair opportunity to make your statement and put the rule on, but not in front of the jury. That's not what's relevant for them. They need to know what the facts are, not what your personal feelings are about this court. Move forward.
That's not the way.
Move
objections
forward,
work,
sir.
I have to tell you what my objection is before.
No, I will do it outside the jury. We'll do it outside the presence of the jury. That's not relevant. Go.
They can do it at the jury selection.
No,
I'm
sir.
about to do it.
No, sir, that's not the appropriate way to do
That
it.
is very
We're gonna
much
follow.
the appropriate way, Your Honor.
I've made my ruling. Move forward. Talk about the facts of the case, sir.
I love y'all. Remember, I love y'all. I'll never forget. This is what resilience is. This is what perseverance is. This is what integrity is. All my family that is watching this right now, this is what integrity is. This is what dignity is. This is what perseverance. You understand me? Don't ever forget this. Don't ever forget this. So, every juror in here is related to an officer in this county. I have a few lawsuits that's naming a lot of officers that did some real foul, atrocious stuff to me throughout these 7 years. The fact that I have a lawsuit pending against this judge right now and the federal district judge, and they still forcing me to sit in front of a jury that's not my peers, it's completely illegal. It's completely overstepping the Constitution. 3 of the jurors had close relations to Mike Laird by their own admission. One of the jurors was related to the guy that arrested me, to the officer that arrested me and broke my phone and destroyed my evidence. That I had, the same officer that I had to prove set me up and framed me at the last trial of a jury that voted in my favor 11-1. Nobody in this country would have voted in my favor. That juror that voted against me was planned, was temporary. I'm still in prison for pointing a gun at somebody. Pointing a gun, which is a misdemeanor. I didn't shoot the gun. I just pointed. By law, that is a misdemeanor. They charged me with aggravated assault. I took probation because I knew nothing about the law. I took probation, I knew nothing about the law. They manipulated the facts. Well, no, they told the truth about the facts on the indictment. But they manipulated the law and said it was aggravated assault by pointing a gun. For 3 years, I was on probation, doing good. Mental health probation, might I add, because I was depressed at the time. I was depressed at the time because I didn't have a job. And I couldn't take care of my kids the way I wanted to. And it was killing me. I was a coward. I was weak around the time because I didn't have the opportunity and the access and resource. But after that situation, and I took probation, I was able to get my head together. It ended up getting me a good job. And I was the sole provider in my household, and we was eating good. You understand me? My probation officer, the detective went to talk to my probation officer, trying to see what he can figure out how to violate my probation. You know what my probation officer told him on the paperwork? He's been in compliance for the past 3 years. He pay his fees. He do his community service. He go to work. He don't do drugs. He's been in compliance. I ain't got nothing to give you. So you know what he did? He sent his officers because this one foul female that I was dealing with behind my wife's back, and it backfired in my face. She got mad behind some money that she know I had nothing to do with, trying to accuse me and want to go to war with me behind some money. And instead of keeping it in the streets like she claimed she wanted to do, she went and lied to them people and told them I raped her. And then she got somebody else that I knew that I didn't know she knew to lie and said the same thing happened to her, but she didn't want to say I did it because she knew I needed it too much. We was too cool. That woman, you can tell how bad she was feeling and how stupid she was feeling, sitting up there testifying about something that didn't happen to her. But she was doing it on account of her friend. Because her friend knew that she wasn't going to beat that charge by herself, because I could have proved that every time we had sex, it was consensual. I could have proved it. Text messages, GPS. I could have proved it. She knew she couldn't do it on her own, so she got somebody else to make it seem like, oh, the situation is identical. If it happened to me, I can't be lying because it happened to her too. Trying to make it seem like she didn't know it. But the girl sat up here on the stand and ended up in me. Yeah, I know her. Oh, you know her. But you told the police report you didn't know me or her. And then you told the police you didn't know me or her. But now in here, when she get on the stand, she, oh yeah, I know him. We only went on one date. I mean, it was only one time. First we went on one date. Then, oh, we only seen each other three times. Everybody, all these people know. They know I didn't do what I initially was in here for. And they know I didn't do the stuff they trying to give me life in prison for. But they hate me so much. The last 3 trials, this man had a white prosecutor. DA Michael Laird, his prosecutors was white. Miss Angela Mann, been his prosecutor. Angela Mann Nealon, been his prosecutor for a while now. I've never seen nobody else working with him except Angela Mann and Waylon G. Thompson, both which are white. But here he is on this trial. He got a black woman working with him to try to defeat the appearance of racism. Like I'm not going to acknowledge that. And then it was somebody in the jury box that was related to her. She probably don't even want to be here. Y'all probably gave her some ridiculous offer to help. And she, okay, all right. That sounds like some good money. Oh, that sounds like a good deal. You gonna Oh, cool. That's a good deal. Other than that, I'm not understanding why this man just got up here and lied and said he never had interactions with me. Why he just sit there trying to lie and say I dashed the officer with some feces. Why y'all sitting up here blocking my subpoena? I filed a subpoena 3 years ago. I filed a subpoena, and y'all clerks were telling me on this case, filed a subpoena on this case, and y'all clerks sitting up here telling me that I can't file a subpoena, that they can't subpoena nobody for me because they can't do it for me.
That's not an accurate statement.
That is very. It's
I'm
on
sorry.
phone.
I'm
I can
sorry.
tell you what day it was.
Sorry, sir. There
I can tell
is,
you what day it was.
once again, I'm going to tell you when I speak, you must stop, please. That's the rule of law. I know you don't like to follow these things, but that's the rule of law. Subpoenas, if you send subpoenas, first of all, I urge you, have an attorney to help you.
I don't
You
need
just,
one.
I know.
I'm a jurist.
You,
I'm an
the,
expert.
the subpoenas you've submitted are inaccurate, incorrect, and weren't properly filed. That is why they were not submitted. And I urge you, get some help so you can do it properly. That's why, sir. And not everybody, that's why people go to law school and become.
Defendant should have compulsory process and obtaining witnesses.
As long as it's done correctly.
I don't need a paper motion if
All
I
right.
ask you on
All
record
right.
in the court to do so.
All right, go to what is relevant. That's enough on
Everything I'm
that.
talking
Go to
about
what's
is
relevant of the allegation of the first degree felony of aggravated assault.
Everything is connected. Y'all only did.
Is there anything else you want to add?
Y'all would have never charged me with this.
Is there anything else you want to add?
If I never filed the habeas corpus, I filed the habeas corpus accusing Joshua Hall, Detective Duchamp, who else? Detective Duchamp, Joshua Hall, Mike Laird, my attorney, of conspiring against me, right? I accused them in a habeas corpus back in 2022, March 9th. Ever since then, I ain't been getting no sleep because y'all want to keep sending people after me in the jailhouse to harass me. And you keep talking about they keeping me in isolation because of my behavior. I was in TDC. I had a job in TDC doing good. But as soon as I filed a lawsuit, y'all transfer me back down here, throw me directly in isolation. And you trying to talk about my behavior. No, y'all don't have me in isolation because of my behavior. You have me in isolation because of these lawsuits. Matter of fact, I'm about to show the world. You want me to stop? You don't want me to show the world? Hit that button and electrocute me right now.
Sir,
Hit that button and
Sir.
electrocute me right now because the world.
sir, why don't you act properly,
Oh,
sir?
I'm acting very properly.
I don't believe anyone in this room thinks that, sir.
I'm pretty sure they don't because they
No,
were all
sir.
handpicked.
No, sir, we're talking about common decency now, sir. The law allows you to speak, but be
Racist
decent.
Peoples versus
Please.
Greg Abbott. Now let me show y'all who name is on the front for it. Whenever you sue a judge or the DA or a prosecutor, anytime you sue a government.
Sir, once again, you're charged with aggravated assault. Stay within the bounds. It is not relevant.
Depending on this too, in the federal court
This-
right now,
Sir.
that y'all real messed up about.
Sir, this is an allegation
Right.
of striking somebody about the head and body. Stay within that allegation.
I'm supposed to be sitting in this court. I'm supposed to be dealing with this in the Supreme Court because my habeas corpus is pending in the Supreme Court right now.
Anything else?
Because of this charge.
Is there anything else you want to add?
Retaliation through conspiracy, right?
Is there anything else you want to add?
I'm going to continue with that.
How long do you expect for this to go on?
It's interrupting me. It's going to take all day.
No, it won't, sir. If it's not going to be relevant to the facts, I will stop this now.
Well, go
To
ahead.
the facts of the charging instrument, sir.
Do your thing.
Then it ends now. That is enough. It is not relevant anymore.
Retaliation.
That
through
is the
conspiracy.
end.
So everything I'm talking
Is there
about
anything else you want to add about the allegation?
habeas corpus in the Supreme Court. Now, I sent an emergency motion, let them know what y'all keep doing to me, how y'all keep harassing me. That Lieutenant Tinker body cam played yesterday. He admitted that he refused to feed me, and he thought that was okay. I wasn't aware of it, so Yeah, it happened, but I wasn't aware of it, so I'm not giving you. I'm not. And
Is
if
there-
it happened again, I
Sir,
will.
is there anything else you want to add as to the allegation of aggravated assault in this indictment?
I'm talking about what happened.
No, sir,
yesterday.
you're not. You're outside all of that.
What-
And you said that it was going to go on for days. This was not going to happen. If there's nothing else more relevant to if there's nothing else relevant to the allegations of this indictment, you have completed your testimony.
No.
Yes, you have, sir. Stay within the four corners.
Y'all called him to the stand because he was relevant to the case, right?
No, you just don't get to give your life story to the end of time. It needs to be what's
It's not like
relevant.
we're talking about. This is not a life story.
That is all,
This is
sir.
not a story.
You have
It's a story.
completed. You are completed, and I told you about, she can't take the notes when you are speaking over others. Is there anything else you want to add as to the allegation of aggravated assault? Stay within that.
Yes, it is. It's a lot of.
Stay within that.
All right.
Thank you.
April 22nd, 2021. I was revoked of my.
Hold on, sir, that is 2 years before this event occurred. What does that have to do with what happened on June 6, 2023?
Well, because
Please stay within that event.
I'm still in prison. Like this.
Okay, they know that. They know that. Move on to the next thing. I'm sorry, it's the charge of aggravated assault. Just speak on those facts that happened on or about June 6, 2023, not what happened 2 years or 3 years before in another case. Thank you, sir. Stay within those rules.
It's not retaliation. If it relate, the law say if it's directly related, then
Stay within what happened on June 6th, sir.
Federal Statute 18 USC 1513 subsection E. Whoever knowingly with intent to retaliate take any action harmful to any person for providing to a law enforcement any truthful information relating to the commission of any federal offense shall not be imprisoned more than 10 years or fine or both. That is a federal offense to take any action out of retaliation for providing to a law enforcement any truthful information. Every trial I've been to, I told the truth. I only open my mouth if it's backed up by witnesses or the record. That's the only time I open my mouth. Whoever caused or induced any person, this is Federal Statute 18 USC 1512, subsection B2A. Whoever caused or induced any person to withhold testimony or other object from an official proceeding shall not be imprisoned more than 20 years.
All right, hold on. Again, that is not relevant to this case at all. This is a state jurisdiction case, not a United States jurisdiction. There's the federal government. It has its own sets of rules, ladies and gentlemen. I was a United States attorney for 20 years.
What about
And this is state law that we're dealing with here. Distinct laws. Distinct law.
Focus on.
Sir, let me complete the instruction of law to the jury. Please, once again, for the 100th time, don't interrupt when the court's given the law. Thank you. That is not relevant to what the charge is in this case. This is a state jurisdiction case with its own elements. We're not trying a federal crime right here in this court. That's for the United States district courts, for the United States attorneys to handle. This is state law. It has its own independent set of laws, and this is what we're dealing with, is state law of Texas in this allegation under section 22.02 subpart B, subpart 2, subpart B of the Texas Penal Code. That's distinct from federal law, and your statements on federal law are not related to the relevance in this case. Please confine your statements that you've been allowed to give here within the four corners of this state law brought crime. Thank you for following the law as instructed.
Yes, Your Honor.
Go ahead.
Mention is, the state part, right? If two or more conspire to injure, oppress, or intimidate any person in any state on account of any right or for exercising the same, shall not be in prison.
What are you reading from, sir?
This is federal statute.
That is, once again, its own set of rules. This is not what we are. We're not a federal court.
18 USC.
I know,
241.
I know. 20 years I dealt with that. And I dealt with the most serious offense in the United States that was committed. So we are dealing with state law, not the federal law. This is a state law matter, and what you're reading is outside the relevance in this case, and you are denied to be allowed to do that. You can put it on the record later outside the presence of the jury. It's not related to what this jury is going to be deliberating on, and it's the state law violation of aggravated assault. Please stay within the directions of the court and the law. Thank you for doing that. Move forward, please.
Why do y'all hate me so much?
Anything else you want to add, sir? Anything you want to add relevant to the case facts
Yes.
and the law as it's supposed to be followed? Thank you.
Yes. So Lieutenant Ford, right? Let me tell you about the Lieutenant Ford real quick. So when he 24, when he first wrote this is the first page of his report. Outside of the one yesterday, the one we were looking at on the second page. This is the first page. Everybody else report identifies every officer that was there, right? But Lieutenant Ford's report only identified Purdy and Hebert. They wasn't even there. Right. Officer Stevens' report identified everybody that was there. Officer Syndergaard report identified everybody that was there. Officer Darby report identified everybody that was there. Sergeant Anderson's report referenced nobody at all. Lieutenant Ford report only referenced the lady that got these guys to jump me 4.5 years ago and knock my teeth out and reconstruct my teeth the way it is. After she divulged my charges to the dorm and told the people I was a baby rape. And of course they don't believe me because she's an officer. So I wrote a grievance on her and I got 10 people that was in the dorm before I got jumped. Before they knocked my teeth out, I got 10 people to witness what she did. You know what the grievance officer told me? You have no evidence. It's your word against hers and then vice versa. This is not a grievance. Right after that, I got jumped. My teeth got knocked out. Captain Lewis and Captain Miller had to come take pictures of me. I woke up with blood everywhere. I woke up with blood all on my face, all on my clothes. Ever since then, that woman been constantly harassing me. She been constantly harassing me. Now, lately, she been messing with my food. I had to put myself on Johnny set because her and Lieutenant Ford teamed up to convince everybody else all the lies that they've been telling people. So Lieutenant Ford, you know, that was Syndergaard. I forgot to ask him that. Officer Syndergaard, he referred me to Lieutenant Ford before me and Lieutenant Ford had any type of of problems with each other. He referred me to Lieutenant Ford as a trustee in fact. Him, Biggers, Officer Jones, what else was that? Officer Jones, Biggers, uh, Washington, Officer Washington, the guy who works. Listen, I gave nobody problems in the gym. I gave nobody problems in the gym. But as soon as I started filing paperwork trying to go home, that's all I was doing. I wasn't trying to get no money from the state. I wasn't trying to get no money from the government. I don't care whatever mistake y'all made. I don't care how much y'all like me. I don't care what type of crimes y'all committed to get me here. I just want to go home. We had this up. I sent the affidavit. I gave an affidavit to Sergeant Carter and told him to give this to Detective Gardner, Lieutenant Ford, and Sergeant Anderson. That affidavit let them know I swear I will testify to this affidavit. I won't file a lawsuit on nobody. None of y'all. Just dismiss the charge so I can go home. You know what they did? Carter came back. Hey man. Hey, I had got a notarized and everything. I told them, man, next time we go over to here, I'm gonna testify to that. They spit in my face. It's in the state. It's in state now, man. We ain't got nothing to do with it. So y'all not even gonna go tell the people that I just want to go home. You know, look, it's about all you. Really? So y'all just want to? You gonna keep me here? All right. Let me forget it. Let me see if the lawsuit's worth. Now here we live. 5 months after I filed a lawsuit on a judge for refusing to issue the writ of my habeas corpus, after my attorney admitted to refusing to give me the search warrants, refusing to give me the search warrants to my DNA, my phone, and my car. He admitted. He lied to me. I didn't give it to him because he wasn't supposed to ask. I was found not guilty. They charged me with 3 aggravated sexual assaults altogether. I was found not guilty at their first trial. My lawyer told me, you get found not guilty at this trial, they don't dismiss the other 2, you go home. Just don't testify. I got you. I'm like, all right, cool. I say, man, make sure you ask her this. All right. I say, man, what you doing? Ask her the question. I'm going to. He kept on trying to divert the attention the other way. And I had to argue with him at the table just for him to ask her the questions that man, you don't know this man. How was y'all getting in contact? How is his number in your phone? Under the text-free app? Well, who told you to download the text-free app? My boyfriend. Call his boyfriend and say, sir, did you tell your boyfriend to download the text-free app? No. What about the birthmark that's on your hip? If I don't know you, we ain't never had consensual sex. What about the birthmark? But because you said this happened in the dark. No one ain't see the man's face or nothing. You said this happened in the dark. How could he see a birthmark on your hip if he couldn't see you? He found not guilty at that. They stopped letting me come to court, period, for about 2 years. In the midst of that, charged me with this. Why is Lieutenant Ford all of a sudden coming harassing me like I did something to him? Why? I hated that man because he kept on. Dude next door squirted waste in my tail because I wasn't selling him a pack of cookies. I'm talking about, and yes, like Lieutenant Ford, it was waste everywhere. I'm not about to put it in my own cell. Ford, bro, this retarded, stupid dude. Listen, Levine won't clean out my cell, man. Can you please make Levine clean on my cell and let me go in and take a shower. Or look, matter of fact, just give me some of that bleach and give me a towel and I clean on myself. Man, I ain't trying to die, man. This corona was serious. It was 2022. Corona was serious, still serious. You know what he did? You need to stop arguing with people. You need to stop arguing with people, grievous, man. Wave his hand. Walk off. My heart must have dropped. So you gonna leave me in this? You gonna leave me sitting in another man's waist? Trustee, come through. Trustee, bro, listen. Slide me the mop real quick, bro. Let me get that bleach right there, bro. Just slide me. No, I ain't getting it in. Bro, just give me this mop and okay. Listen, I ain't getting that. You ain't about to make me lose my job. So I dashed him with water. Water. He go tell Lieutenant Ford. You know, cuff up. Cuff up. So you're not gonna let me explain why I dashed him? I don't care. Cuff up and explain to me when I take you to your isolation tip. What? You gonna put me in isolation for dashing an inmate? But you gonna leave me sitting in this? No, you're not about to punish me. No, why you doing that, man? You're not about to punish me for dashing an inmate for refusing to give me some chemicals to clean up this waste that you refuse to make the CO do. You're not about to do that. Cause I ain't never did nothing to you. That man can't ask me, did you want to be a trustee? I'm like, yeah, man, I've been trying to be a trustee. Man. Come to find out, he only asked me that because Biggers referred me as a trustee. I'm like, oh, that's why he can. Because Biggers let me know that, man. I told him, man, only person back here competent to be a trustee. You know what I'm saying? You don't give me no problem. Like, why he ain't named a trustee yet? Because he can't ask me. You know what I'm saying? All right, don't worry about it. Then next thing I know, I had this little situation with the dude squirting away from myself. He ready to ride down on him. He ain't trying to do no talking, cuff up, or I'm coming there and get you. What? Really? You ain't gonna clean up this waste, but you gonna come in here? Oh, you gonna come in here to hurt me, but you ain't gonna clean up. All right. Come on, let's fight me. Because I'm not cuffing up. Now I'm not about to cuff up for you to hurt. Now I cuff up for you to clean this white cell out, and then you can write me up if you want to, and block my privileges. But you're not about to come in here and put me in an isolation cell after refusing to clean out this net. So then Lieutenant Ford, after he do all that, after he run down on me, after I get done dashing him with the water, not waste. Even then, even him leaving me in somebody else's waste, I still didn't have the mentality to stick my hand in the toilet that's the being in another man's waste I was throwing up. So I can't touch my own. Listen, somebody else's. I'm in there gagging because he don't want to clean the cell out. So I started dashing him too because he wanted to punish me. Yeah. He get me to the isolation cell, right? But man, this day I didn't swing at nobody. I didn't threaten to stab nobody. You know what I'm saying? He get me to the isolation cell. I had all my paperwork, all my legal work, my legal books, my kids' pictures I would never get back. Pictures I would never get back. He threw all my stuff. Threw all my stuff away. He threw all my paperwork away. All my books that my sister bought me, all my legal books, my checks code. I couldn't even file a motion with the Supreme Court. My prisoner discharge motion with the Texas Supreme Court of Criminal Appeals because he had to throw all my stuff away. You know what I'm saying? I wrote a grievance about it. For my whole month, I'm steady begging my stuff back. I'm letting them know, look, man, I'm sorry, I will give y'all no problem, man. I clean this stuff up with some jail soap next time. I ain't tripping. Just give my stuff back. I'm begging for my. I never seen my stuff again. He threw all my stuff away, or he gave it away. One of the two. I don't know. It's a lot. You know what I'm saying? I keep a lot. I had a lot of paperwork. I keep a lot of paperwork because I'm always either writing my kids, studying the law. I'm taking notes, doing what I need to get back to my kids. Throw it all away. I'm like, all right, cool. So I see what type of time you on. You know what I'm saying? You trying to shield me, and you trying to keep me in prison. Okay, cool. Let me stay out this man's way. He ain't playing no game. Let me stay out this man's way. He came back a couple months later, came back to that same cell we put me in. Hey, you want to move the indoor? No, I don't. I'm not leaving out this cell. Because this cell I'm protected in. It's a camera right there. It can see everything. I'm not leaving out this cell. Y'all not. They're like, what about indoor? Now, man, this is Lieutenant Ford I'm talking about. What about indoor? You want to move to indoor? No, I'm good. I'm not leaving the isolation cell. I'm protected. Can't nobody throw no waste in my cell. Nothing. You can't take my paperwork without it being seen. Nothing. Right? But then he had somebody else try to come. He had a couple other people trying to convince me to leave the cell because he needed it. Oh, I don't care what you need. I need this cell. You go home. I need this cell. I'm not about to put myself in a situation where somebody else can do what you did. Turn around. This man back door. Wake me up. Hey man, we gotta do maintenance in the cell. So pack your stuff and move in the ISO 1. Mind you, I was going to the day room. When I go to the day room, they let me go to the run day room, right? Because I don't cause problems. All the other inmates back there, they gotta cuff up and go to the day room out back in isolation. In isolation, you gotta keep the cuffs on. But because I never gave the officers problems, they will always let me go to the day room on the run, put me in the cage, take my cuffs off, so I can take me a shower, so I can do my legal work, so I can talk on the phone when I want. You know what I'm saying? You can't do that in the isolation hallway like that. You know what I'm saying? You can't watch TV like you want in the isolation hallway. They let me go to the run, so every time I go to the run, I gotta pass up all the cells, right? On my way to the run, the day room the night before, it was a mentally deficient dude. He really had a real bad mental illness. He played with his waist all the time.
Mr. Peoples, hold on. Do you have much more to go on? Because it's into the lunch hour. This jury has been in here for a long time. Do you have much more to say?
He said talk about the case. I'm telling
Do you have much more to say is the question.
Yeah.
Then we're going to break for lunch. Can all of you return back at 2:00, ladies and gentlemen? 2:00. Thank you. Please remember the instructions the court has given to you. Thank you. And the jury is seated in the courtroom. All parties are present. When we rested last, the defendant was making his statement in his case in chief. You may pick up, sir.
So, never caused no problems. Isolate. Not this time in isolation, but time where 3 years ago when they charged me with this charge, right? Never caused no problems in isolation, so all the COs would let me go to the day room in the cage on the run. The videos, the pictures that y'all seen, where they took me and put me in a wrap, that's the day room on the run. They can take the cuffs off you and let you work on the computer, talk on the phone, watch the TV, take a shower, right? In isolation, your movement is very limited and whatnot. But I would refuse to go back to the run because there was too many people playing with waste, too many officers that on a regular basis that like to take my paperwork. It happened actually 2 times. So after the second time I wouldn't go back to the run, I just go to the run to go to the day room. So when I passed by that cell the night before Ford came to have fun with me, when I passed by that cell, I seen dude, it was streaks of his waist smeared on the window. And he even had it on his body. When I came back, he was still in there. After my hour day room, they put me in that back in my cell, isolation cell 6. A couple of hours later, he got moved to infirmary ISO. Nobody ever came from that cell. I'm saying, I was up practically all night. Nobody ever came from that cell. That morning, when Ford came woke me up, it was around 7 or 8 o'clock. I'm letting them know that I just need somebody to clean the cell out because they moved that dude last night. I need somebody to clean the cell out. All he kept saying is it's already been cleaned. It was cleaned last night. I say, no, it wasn't. No, it wasn't. Can you please have somebody clean it up? No, it wasn't. He insisted that it was cleaned last night. He telling the other officers. Even Stevens, I'm telling Stevens, bro, can you please just go clean the cell out, man? He said it was already cleaned out, man. We just need you to go in there. So when I told Darby just actually finally decided to go down there himself and clean and look, check. When he got back, he said, yeah, I see what you're talking about, man. But listen, once you get in there, I'm gonna make sure you get some. I'm gonna give you chemicals. Once you get in there, we take stuff. I'm gonna make sure I give you chemicals and a mop and such. I say, nah. Last time he wouldn't let Levine give me that stuff. I don't trust him to do that. Just listen. When he walk out, just go down there, sneak down there, and throw it in the cell for me. Just throw it in the cell. He said, look, man, just come on, man, stop giving us a hard time, man. No. Why is y'all thinking that is okay? It's not okay. Now, all 3 of those officers sat in his chair and told y'all the same. They all told y'all that I was complaining about this cell being nasty and wanted it to clean up at that very moment, which means everybody had knowledge of my contentions about moving in that cell without it being clean, right? So that was a simple fix. Throw the chemicals in there in the mop, in a rag or something, and I'll do it myself. He wouldn't even let them do that. And they kept trying to make excuses for me to just chill and do what he's telling me. Now, if everybody had that knowledge, why is they only taking pictures of isolation cell 6? Okay, everybody know I'm in isolation cell 6. Why do you need pictures for isolation cell 6? Why are you not taking pictures of isolation cell 1? Why is everybody hiding the evidence of them trying to indirectly kill me and trying to make it seem like I'm some type of thrown off, chaotic person? I haven't done nothing to nobody in this jail for them to be doing it, which means somebody got to be sending it. I'm talking about one after another. Where did this come from? I ain't never had no problems with Tinker. Why he did that? Yesterday, when I got back to the jail from this court, I've been, like I said, this is my 4th trial. I came to hearings plenty of time. They ain't never searched me coming back from court. They'll search me going to court, and they never search me coming back from court because there's no need to. Right? Like, yeah, when I get back from court, Lieutenant Davalos and Sergeant Hawkins made me strip out butt naked, squat and cough while the cameras was going. And they stood a distance so the camera could see my whole body. I'm asking them, what is this? Is this to make me, what? So somebody told y'all to record this so they can have some fun afterwards? Why y'all got y'all recorders on? Y'all ain't never made a person strip out while recording. And why is it taking a rank to do this? The officer, I ain't never been strip searched by no ranking officer. It's always a regular CO that'll strip search me. Why is it two ranking officers with their cameras on, standing just 3 feet away from me, enough for it to see my body? They got their heads turned like they don't want to see me. Somebody had to send them to do that. Right after I left court, yesterday. Humiliating me. For what? Because Ford told him to? Because Ford admitted that I didn't stab him? Because they know the jury gonna find me guilty regardless, no matter what I say, and it won't add up?
Anything else?
Yes.
Please get to the end, sir. Thank you. And again, stay within the four corners of the allegations. I've said that. That's what we're here for. Whether or not you have committed this crime of the first degree.
Talking about Ford.
I'm sorry, sir. Let me complete my sentence, please. She's counted up how many times you have interrupted the court during this hearing, and it's numerous times. Let me speak, and you have a fair opportunity to be heard. Stay within the four corners. That's what's relevant.
All right.
Four corners of the accusation. Thank you for following the rule. Go ahead.
So, well, the habeas corpus to this case, November 15, sent the habeas corpus to the court, November 15. It was filed in December or whatnot. The habeas corpus was explaining how Lieutenant Ford's statement admitted that I did stab him. And I also explained why I was combative, which made that charge completely illegal, right? In America, right? In this country, when an indictment isn't in the four corners of the allegation, right? That is, there we go. There's grounds for dismissal and to produce the body. That was like 10 months ago when I filed this, right? They wouldn't even give me a hearing for it, right? The habeas corpus is that thing that Donald Trump wants so much to abolish because of situations like this.
No, I'm sorry, sir. You're misleading the jury. Habeas corpus, he is getting his time at trial. He wants his time at trial under the Constitution. That is his habeas corpus hearing right here, essentially, but with you and the jury. It was indicted. I don't make the decision on indictments. He didn't come to the judge for the determination of guilt or innocence. He has insisted on a jury trial, and with this being the 617th jury trial, we're trying as much as we can, as fast as we can, ladies and gentlemen. But under the law, this is what equivocates to a habeas corpus proceeding. This is the trial by jury. He has been insisting. He has it, and that is irrelevant. You can move forward. This is your time to be heard, sir. So I'm allowing that in spite of the difficulties here. Please proceed and move forward. Thank you.
Your Honor, I would like you to issue the writ of my habeas corpus, my pretrial habeas corpus for this charge.
Okay. That is denied because it is not presented in the correct way under law. That's why I've asked you, please work with an attorney to help you do it correctly. And when you insist on representing yourself, you have to follow the rules like all others. And the court is the person who makes the ruling like a basketball official on the court.
Article 1148, written issue not necessary. It shall not be necessary on the trial of any cause arising under the habeas corpus to make up a written issue, though it may be done by the applicant for the writ. He may accept to the sufficiency of or controvert the return or any part thereof or allege any new matter
Okay.
and avoid it.
Sir, I'm going to present the law that's necessary for the deliberations. A writ of habeas corpus does not substitute for a trial by jury, ladies and gentlemen. This is what he has asked for. He's getting the trial by jury. An application for a writ and a writ hearing is a separate, completely different sort of circumstances. This is what the Constitution allows, a trial by jury, and we've got him here as soon as we were able to get him in the queue with our trial backlog that we have in this county, but we can only try one at a time.
All persons is innocent until proven guilty.
No, sir, that's incorrect. The jury knows
My bad,
that.
My bad. All persons are innocent unless.
There you go.
proven guilty.
Good for me.
Right. So at my probation hearing, when you said based on the scientific.
No, sir, we're not getting into the probation hearing, sir. I'm sorry.
I sentenced you to 20 years.
All right. That, you keep interrupting the court, you will be placed outside.
I was talking.
We're going to have right now, the jury is going to be excused. This is a trial about the allegations of this indictment, and you have to stay within the allegations of the indictment, sir. We're not going to torque off on hearings that are not relevant to this trial, sir. And also, I have instructed you about interrupting the court so I can make a ruling with the court reporter. When you keep interrupting, I am unable to do my job. I've asked you not to do that. You keep continuing to do that.
I was talking to you.
You were speaking about something that had nothing to do with this trial, sir. The next time you interrupt, you will be placed in a holding cell. We will have the trial for you to listen to. That's the way the rules say it happens when you keep interfering with the rules of decorum. Do you understand what will happen? Please follow those rules, Mr. Peebles. I want you to get what you want said, but if you keep interrupting and not following the rules, I don't have any choice but to change the circumstances. And you are the only one in this room who keeps not following the rules. Please follow the rules, and you have a chance to be heard and stay relevant to the allegations in this indictment. Do you understand, sir? We're in short recess.
Like to continue, Your Honor, or like to request to continue.
No, that's denied. We're going to complete this trial. Court is going to make some findings here that the defendant is intentionally prolonging these proceedings by refusing to follow the instructions of the court, by bringing forth statements and thoughts from matters that are irrelevant to the four corners of this indictment. He has been instructed numerous times to follow the rules. He continues to disobey the rules. He continues most often to interrupt the court when the court is making its rulings and findings on the record, which prevents this court from doing its job. And I've warned the defendant, if he keeps that up, we have no choice but to put him in a different room where he can listen and watch the proceedings without interrupting them. We'll see what happens. This has been consistent in this trial and railing on about matters that have nothing to do with the four corners of the charge is obviously an attempt to prevent this trial from ever ending.
Yeah, I have them.
And the court has a duty to
Any other case, please.
move forward on a trial in an expedient way that's fair to all. And he's preventing that from occurring. All right, let's bring him out.
I got this one taken care of, and I took care of the first one with just Dollinger. I did that for the last 30 minutes, I got more done in 30 minutes than I have in there all day.
All right, let's get the jury in, please. Thank you, Kendall.
Always fight for what you know.
Sir, do not speak except to answer the questions while the jury is here. Don't be making statements in front of the jury, sir, that aren't part of the question and answers. Let just show the jury is seated. Thank you, ladies and gentlemen, for your attention and your patience. All right. Mr. Peebles, you may go forward. Be mindful of staying within the relevancy of the four corners of this indictment as it is alleged. Thank you. You may proceed.
Lieutenant Ford, I was cussing him out one day, and he said to me, you must love living in church. I said, no, I'd rather die on my feet than to live on my back. He said, that's so she could, he tell me like that, that statement is so clear. Okay. That's because you used to doing people like me the way you do them. Something like that means nothing. I told him it means a lot to my kids, though. And I'm gonna make sure my kids understand to always fight for what you love. That's what I told them. I said, man, listen, I would not be a good role model if I gave up on my kids. So, you know what he had started doing? He started having people tamper with my mail, blocking their access to the courts. He once they bid for me, I'll be out at June 25th, 25. I had wrote a complaint on the federal judge about allowing Judge Stevens to keep me in prison in violation of the habeas corpus procedure. 3 weeks later, he had me bench warrant out here. 12 months ago. 3 weeks later, he had me bench warrant out here. Threw me directly into an isolation cell, blocked my communication about 5 months. And the whole time, Lieutenant Ford would cut my water on periodically. And I would have to argue and trip out about it just to get it cut back on. And that complaint was on a judge for him refusing to rule on my habeas corpus.
Wait, hold on. So the jury is clear. Are you saying that I ordered sanctions against you in the jail? Is that what you're telling this jury? Is that what you're telling this jury, sir? Under oath.
I'm telling the jury that Lieutenant Ford is able to be doing the stuff that he's doing to me the past 12 months because I wrote a complaint on a federal judge for refusing to rule on my habeas corpus, which was complaining on you. And 2 days later, he ruled on it, but I was bench warrant out here. He ruled on it July 16, 2025. I was bench warrant out here July 18th, 2025. But June is when I wrote that complaint that sent it off, which means it took about a week to get to the court, which means it only took 2 weeks for me to get bench warrant out here through an isolation and said after he denied my relief.
The federal, you're telling the jury that the federal judge denied the relief you were requesting, correct?
Right. And
Okay.
he bench warrant me out here.
All right.
I mean,
Move forward.
that's the only way I can be bench warrant out here. How did you know he denied my relief? Just 2 days before he bench warrant me out here. And when I get out here, y'all put me directly in the isolation center. TDC, I wasn't in the isolation center. I had been in TDC for like almost 2 years. But as soon as I filed a lawsuit a few months before and a complaint a few weeks before, I get bench warrant out here and harassed at an extreme rate for 12 months by Lieutenant Ford and his co-conspirators. I sent off an appeal for that habeas corpus. August 8th, August 6th, it was filed August 14th. In that appeal was my certificate of appealability. I had Sergeant Knott walk me to the lieutenant's office to call the court because I couldn't use my own phone because they were blocking. So he walked me to the lieutenant's office. Mind you, they will only do that if you don't cause, if you're not a problem. So he walked me to the lieutenant's office and he let me call the court. I called the court and I asked them, did they get my notice of appeal and my certificate of appealability along with my emergency. They say no, all we got is the notice of appeal. It was under review for jurisdiction. They know, which means all of that went in the same letter. It was in the same envelope. So for my notice of appeal to only be there, and then my certificate was identified on that notice of appeal. But my notice of appeal not filed. Not notice of appeal. My certificate of appealability was identified on that notice of appeal. So for my certificate of appealability to not make it, will only have to mean somebody at the jail took it out of my envelope before it got there, or the clerk had it simply was not bothered and throw it away. Sergeant Knott camera was going at the time when I called, and my anxiety went crazy. After that, they denied. I had to send off another certificate of appealability. And I started giving my envelope directly to the COs. For them to give it directly to the mail agent to get off the unit. And write their name and the time and the date on the envelope, just to make sure it got off the facility. When I sent my other certificate of appealability, they end up denying it. Turned around, I sent the emergency motion for reconsideration. I called court on the 9th of January. My certificate was denied on the 30th of December, which makes the deadline would have been the 14th of January. I called on the 9th to make sure they made it. And they said, I called on the 9th to make sure whether or not they ruled on my certificate. They said my certificate was denied on the 30th of December. So I sent off my motion for reconsideration on the 12th. When you're in prison or any type of institution, The day you file a motion, the day you put your motion in a penal institution facility is considered filed. But they told me I was on time because they ain't getting to the tune. Throughout this country, in every state, the rule is the day the inmate places his motion in a penal institution mailing system, it is considered filed in the court. But they refuse to follow with the panel. For them to do that, a judge haven't allowed them to do it. So they wouldn't address the issue of this charge and all the other charges. So after that, I filed a habeas corpus with the Supreme Court. The Supreme Court will not file your habeas corpus if you don't do it right and if it is not in good faith. But yet they filed it. They docketed it. And one of the justices denied it. I didn't know they went this far. I thought I was safe in the Supreme Court. But the fact that I sent off an emergency petition for rehearing June 9th, and I'm sitting in this courtroom witnessing what just took place the past 2 days, especially at the jury selection, I know that it must be people in the Supreme Court allowing them to do this because they will not let me go to this trial no other way. But then when I do get to the trial, they violating every right in the Constitution. Every single right, especially the 6th Amendment. And I want everybody to know this. Even if you give me life in prison, that will not provoke me to hurt myself or nobody else. I'm gonna make sure my kids understand resilience, perseverance, integrity, dignity, honor, decor. It's very important. Never let nobody take that away from you. I'm done.
Hold on. He has a right under the Constitution for cross-examination, sir. Did you want to ask any questions?
I don't need to talk to him.
Okay, you're excused. All right, anything else, Mr. Peebles? Do you rest? I take it from your silence, you're resting your case. Anything, redirect from the state?
No,
All right, ladies and gentlemen, we're going to take a short break here. The court is going to finalize the jury instructions that we've been working on, and we can't finalize them until the parties have rested. And then we'll bring you in and go over the charge, and then the parties can make their final arguments to you. You'll go into the Thank you. That's our plan. Thank you. Everyone else remains seated while the jury exits. The court has provided the parties with jury instructions. We're going to go over these. Mr. Peebles, make sure that these are in order. 2 verdict forms. We, the jury, find the defendant guilty. We, the jury, find the defendant not guilty. The state, any?
Judge, there's an issue back when you got the definition of assault, and the next one says assault on a public servant. That's not the correct definition of assault on a public servant. Aggravated assault on a public servant. It's just an aggravated assault.
Section 20, it's under section 22.02 called aggravated assault.
No, it's under,
That's the way
it is, but it's.
That's the way it was indicted, folks.
It's not, no, but there's more to it than to be a public servant, not an aggravated assault. See, you got it.
No, I know it's called, but it's called aggravated assault. It's under section 22.02, which is aggravated assault. It's a form of aggravated assault.
I understand that, Judge, but you put aggravated assault of a public servant, and nowhere in that definition does it have public servant a public servant in the performance of his duty, which is what it's supposed to have.
Okay. I think it's a person commits the offense of aggravated assault if he commits assault against a person the actor knows is a public servant while lawfully discharging an official duty. All right. What other changes?
No other change. Judge.
Anything, Mr. Peebles, you want to change on these instructions?
Wish I can change the word.
I wish I could change the world, what his statement is. All right. Please make this change. Otherwise, any other objections by the parties?
No, Your Honor.
All right. We'll make this change, bring the jury back and read the charge, and then the parties can make the final arguments. Record shall now show that all parties are present and the jury is present. Anything to bring up further by the party, state,
No, Your Honor.
and Mr. Peebles on defense? Anything further? There's no answer. Earlier I asked and Mr. Peebles said, I wish I could change the world. So I'm going to move forward here. And at this time, the court will read to you the jury charge of the court, which contains the law applicable to this case. Ladies and gentlemen, in continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions previously given to you. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will. When I read this charge to you, it will be left with you to refer to as necessary during your deliberations, ladies and gentlemen. Members of the jury, the defendant stands charged by indictment with the offense of aggravated assault against a public servant alleged to have been committed in Jefferson County, Texas, on or about June 6, 2023. The defendant has entered a plea of not guilty to this indictment. Our law requires that I submit the following charge to you in this case. This charge contains all of the law necessary to enable you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided. Charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about June 6, 2023, the defendant Raymond Peoples did then and there intentionally, knowingly, or recklessly cause bodily injury to Charles Ford by striking Charles Ford about the head or body with pens, and the defendant did then and there use or exhibit a deadly weapon, namely pens, that in the manner of its use or intended use is capable of causing serious bodily injury or death during the commission of said assault. And the defendant did then and there know that the said Charles Ford was a public servant, namely a Jefferson County Corrections officer in the lawful discharge of an official duty, to wit, transporting said defendant with the correctional facility. You shall find the defendant guilty of the offense of aggravated assault against public servant. Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt, after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. You have a right to consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are in this case. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. And it is improper for any juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they have any outside information, they must not mention this information to any other juror nor consider it themselves and arriving at a verdict. Questions and comments of the attorneys or parties, if they represent themselves, do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys or the defendant representing himself that is inconsistent with the law contained in this charge. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question about the law develops during your deliberation, it must be reduced to writing and signed by your foreperson, and then be given to the bailiff. The question will then be answered by the court as soon as possible, to the extent allowed by the law. Any physical exhibits which have been admitted into evidence will be furnished to you by the bailiff upon your request. After the attorneys and the defendant present their arguments to you, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision or decisions, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence. There are two options you have. One, we, the jury, find the defendant guilty of the offense of aggravated assault against public servant as charged in the indictment, placed for the foreperson to sign. Your other option, we, the jury, find the defendant not guilty of the offense of aggravated assault against public servant as charged in the indictment, a place for the foreperson to sign. Of course, only one jury form can be signed. Under the rules, the state of Texas may open and close final arguments. What says the state?
State of waive its right to open, reserve its right to close, Your Honor.
Okay. The state has waived its opening. Mr. Peebles, you can move forward and give your final argument now.
During the video, during examination of the video yesterday, you all seen and witnessed that when I exited the cell, I never swung or struck anybody with those pins. Even more so, what's his name? Sergeant Anderson blatantly said I struck Lieutenant Ford with the pins after Lieutenant Ford admitted that his injury came from my fingernail. You also heard the testimony of everybody that say they don't remember seeing me strike Lieutenant Ford at all with the pins. 5 people was there. Only one person said that. 4 people is not gonna mistakenly miss
something so explicit, especially the way it was strapped to my hand. Clearly, I was doing what I was doing to deter his actions and discourage the constant harassment. Clearly, that didn't work. So, being that didn't work, I obviously had no intentions on stabbing him. When I grabbed his face, I could have gouged out his eyeballs. I didn't do that. Clearly, my intentions wasn't malicious. I just simply wanted the cell cleaned, which by law, that's cruel and unusual punishment to force somebody amongst something like that. But yet, everybody, exhibit, one, two, no, I forgot which one it was. But after I showed, what's his name, Detective Gardner, his report, he said he did write this or whatnot. And one of the papers is he stated in his report, Lieutenant Ford indicated in his report that Peoples exited the cell holding a pen in each, and holding the ink pen in a manner to use as a deadly weapon, but he believed the visible injuries he received come from Peoples' fingernail. His aggression was focused on Lieutenant Ford as he used the ink pens to cause several lacerations on Lieutenant Ford's face, neck, and upper chest. Several of the wounds were close to Lieutenant Ford's right eye and could have resulted in more serious bodily injury. So, regardless of how they manipulate the law on the instructions, the indictment is clearly stating that I stabbed him. His probable cause affidavit is clearly stating that I stabbed him. His report explicitly demonstrates that I stabbed him. The indictment expressed that I threatened with imminent bodily injury, which would be force of a violent nature, right? Which would be assault, not aggravated assault. Aggravated it becomes aggravated when you use a weapon. Simple as that. Or cause serious bodily injury. One of the two. Use, not just exhibit a weapon, not just hold a weapon. When you exhibiting that weapon, you have to actually use it. Which means if you have a knife in your hand and you cut somebody, that's using it. If you have a gun in your hand and you shoot somebody, that's exhibiting it while causing serious bodily injury if that bullet hits them. Exhibiting it is merely a description of a remote injury. That's it. A threat to cause death or serious bodily injury by the production of a weapon or otherwise, as long as the act or purpose is limited to creating the apprehension that he will use force if necessary, does not constitute deadly force, which would be aggravated assault. Penal Code 9.04, Texas Penal Code 9.04 is what that
Sorry, I'm
was.
gonna have to object. He's stating law that's not in the charge and is not before the jury.
The objection is sustained. Ladies and gentlemen, you can only consider what is within the jury charge and the law that the court has given to you. That is what the law states. It's in the judge's domain the law to be given to you based upon the law. The parties are not allowed to supplement the law during final arguments, or to change indictments or to change the laws. So your objection is sustained. Move forward, sir. Thank you.
A person commits an offense if he recklessly engages in conduct that places another in imminent danger of serious bodily injury. The production, reckless and danger are presumed if the actor knowingly pointed a firearm in the direction of another or not, whether the actor know or not. That's what I have 20 years for.
I'm sorry. Once again, if two people speak over each other, when an objection is made, Mr. People, you have to stop. You will have an opportunity to complete what you need to say for the record. The objection is sustained. Did you want to add anything else, sir?
Yes.
Okay.
I also want you guys to be aware that, so the day that the judge violated my probation, he gave me 20 years for the aggravated sexual assaults or whatnot, and then I went to trial afterwards and found, and it was found not guilty.
Hold on. Yeah,
I want you to understand
Sir,
that
hold
was
on.
double jeopardy.
hold on, sir. Hold on, sir. So the jury understands this court doesn't violate anybody's. I'm not violating anybody's probation. If someone is on probation, a motion to revoke probation is filed by the executive branch of government. It's not a jury trial. A motion to revoke probation gets heard strictly, exclusively by the judge, and the judge makes its determination based upon whether it's a preponderance of the evidence standard or beyond a reasonable doubt, based upon the circumstances. But just so that you understand, so that you're not confused, this court doesn't violate anyone. And in the way that term is used properly in English. But if someone is on probation and violates probation and there's a hearing and the court finds that enough hearing supports the allegation of violation, then the court can grant the motion to revoke probation, then find the defendant guilty, and then the court has the authority to set a sentence based upon additional information that the court may receive for sentencing. That is the way that works. But once again, just so that you don't, so that you're not misunderstanding, this court doesn't violate a human being. I don't violate people. That's misuse, and I don't want you to misunderstand. But a person on probation, if they violate the terms of probation, not me, but if a defendant does, by proof, then the court can revoke probation and sentence a defendant. That's the way that works in motions and revocations of probation. This is not a revocation of probation here. This is an indictment separately alleging what you've heard throughout this case and what was read to you and what the court instructed you on under its instructions. All right, Mr. Peoples, you may go forward.
And yes, the judge is right. A court may violate a person if they're on probation or whatnot, if they have jurisdiction of that charge that they're violating that person on. But if they never had jurisdiction in the first place and that charge wasn't supposed to be in their court, they was never allowed to violate. It wasn't sanctioned. That act wasn't sanctioned by law at all. Actually, that's an understatement. They never had any legal right, period. No power to violate that probation. Correct, Judge? Is that correct? Is that right?
I believe the jury is making a determination on the indictment, sir.
Right.
The probation, any probations are not part of this case. Please strictly stand by what's been charged so that the jury is not confused. Thank you.
So
let's stay with for this indictment. Thank you, sir.
On this indictment, they plan on giving me 15 years to life.
Cases have been final and approved and affirmed. Move forward with this argument. Thank you, sir.
I was just asking, was my interpretation right of the indictment that I have now?
we're talking about the indictment. There is a presumption of innocence, and I,
of the indictment. I mean, the Sixth Amendment would be getting violated when it says the accused shall be confronted by the witnesses against him. So if the court says that the jury is bound by the law, right? You know, for the love of God, right? By law, I'm not supposed to be convicted of this crime. Correct, Judge? Or did I
you
miss
don't
like
ask the court questions during final argument. You know that, sir.
Oh,
Make your final argument.
I just thought you were going to
Thank you,
interject.
sir.
So the implements for an escape. The fact that the detective himself wrote that on one of his reports that the victim believes that he was scratched. And then on the other one, he admitting that I told him I had no intent, nor do he have any evidence of any intent to escape, right? It makes that those two factors also makes both of these indictments illegal. So, you know, that's pretty much all I got to say about this. And and also the law says whoever knowingly have knowledge, whatever officer knowingly have knowledge of the illegal confinement of the person that they have detained shall issue the writ without delay. Code of Criminal Procedures 11.15. And it is his duty to issue the writ without delay. That's 11.05. Penal Code, not Penal Code, Code of Criminal Procedures 2.03. The state, the prosecutor, the judge, and the attorney representing the defendant, with all attorneys, all court officers, shall conduct themselves to find to seek justice, not impair the ability of the accused to prove his innocence. 2.03 Code of Criminal Procedures. I'm done.
All right, statement close.
Y'all for your patience this last few days. I hope you could appreciate that, and you cannot deny that, because if you deny it, then you have to say, I don't recognize the fact that he wrapped his hands in cloth, getting ready for battle with pins in them, and came out of that cell with his mattress out in front of him. Why did he wrap his hands with cloth and put pins in them? And why was he coming out of the cell with those if he wasn't intending to harm anyone? Second, you heard Lieutenant Ford say in his testimony that when Mr. Peoples reached for his face, lunged at him, which you've heard a couple of them say, lunged at him with his hands, he still had those pins in his hands and all he felt was pain. And yes, there's some scratches on there, but you also see that little sharp one. And that's where Arliss Anderson saw, standing right next to where Lieutenant Ford was struggling with this man, who all he had to do was say, I'll go down to the other cell. And he had a chance with Mr. Darby up here on the stand. You remember Mr. Darby walked all the way down to that cell and stuck his head in there, was in there for 30, 40 seconds looking around. And he did not come back and say, yeah, you're right. Because he could have asked him that while he was on the stand. And none of that ever happened. Darby said he went down there and looked, and the cell was fine. And all the officers went down there with him afterwards and said the cell was fine. So all that stuff he's doing is just a smoke screen, just like it was for that when he threw himself on the ground because he didn't get a tray. He doesn't get his way. And so he starts just doing anything he can to try to get his way. It's all about Mr. Peoples. Everybody's out to get Mr. Peoples. The appellate court's out to get Mr. Peoples. The judge is out to get Mr. Peoples. I'm out to get Mr. Peoples. I even have some influence with the Supreme Court of the United States and the Court of Criminal Appeals. I don't know where that comes from because I've never even been to the Supreme Court or the Court of Criminal Appeals, but that evidently I have influence there. I've wrongfully indicted him, wrongfully convicted him. He's doing 20 years in prison for something that he shouldn't have done. And he won't even accept responsibility for that, even though he knows he pled guilty to it. And we'll cover that later. But he can't just say things. He can't just come up here and say things because everybody in that whole unit said that he came out with those pens and was flailing them around. They didn't see who he hit. A couple of them didn't see it, but Arliss Anderson saw it. Lieutenant Ford saw it coming at his face, and those pins were there. The wrapping was there. Everything's there that said happened. And you don't have to agree. You need to know that under this law, and you can look at the law. You do not have to agree on whether you think he did it intentionally or knowingly or recklessly. Some of you can think he did it intentionally. Some of you can think he did it knowingly, knowing he might cause injuries. And some of you can think he did it recklessly by the fact that he did it, because all that is an aggravated assault, and it's against a public servant who's doing a lawful duty. That cell was being decommissioned. You've heard them all say it. They have to follow certain standards. They were decommissioning that cell. They had to do some work on it to make it safe for them. And then you get back to, why do you have to do stuff on cells? Because, even introduced it in here, people get out of their cells to attempt to escape. This man did. He introduced it himself. He entered his cell, plugged up the cell lock, and walked out and was wandering around. They caught him in a trustee uniform, walking around with a blanket where he could get out. All that's the stuff he was introduced. So y'all need to think about this. This man does not tell the truth. He gets up here and lies. He lies to them about the trace. He lies to them about the phone calls. He lies to you about the law. He's just doing anything he can to get his way. Don't give him his way. Don't reward him for being the person that he is. These people that have to protect you while they're watching people in jail, prisons, they have enough to put up with just dealing with the day-to-day stuff and making sure that everybody's safe and everybody gets what they want. But then they have to deal with people like Mr. Peoples. This gentleman over here does nothing but cause them misery, heartache. You heard them. They all have dealt with him. Even Lieutenant Tinker, bless his heart, you could see him trying to be nice and just come on down and get in your cell. And what's he doing? Grabbing the cell, holding on, arguing, and then he starts yelling those words. And I want y'all to remember those words he was yelling from inside that cell. I'm going to kill. Now, I'm not going to repeat the N word that he used.
Why not?
Don't.
That was being yelled out by this man in that cell. Why would you yell that out over a stupid tray that came from Tuesday on a Sunday, and you don't get your Tuesday tray on Sunday? They don't do that. And the lieutenant ended up giving in to him and giving him a tray. It just rewards him. So I'm asking you, when you go back here, you look at this, it's apparent from the injuries on Lieutenant Ford. And I'm not going to harp on them. But you do need to remember why we're here. We're not here because he didn't get to go get his way. We're here that right there is not from a fingernail. This right here is not from a fingernail. Those are sharp instruments coming down, and it didn't come down because he was trying to distract him. He was trying to get him in the eye, guys. He's trying to poke him in the eye, and he missed. That's why it came down here, and it's down here all the way down because he was swinging. So don't feel sorry for him. You should feel sorry for Lieutenant Ford, who has to go through that every day with this man. Don't reward him for being the way he is. That is not what you do with people who throw fits and try to hurt people in jails that are just trying to make sure everybody's safe. including the people outside the jail. If they're trying to get out, they're trying to harm people in the jail. Do you really think those guys, that this is that important, that all those people would take time out, even people that left? If this man didn't do something that serious, why did they come up here? And Lieutenant Ford, if you want to think he's a liar, wouldn't it have been easier for Lieutenant Ford to say, hey, I saw him stab me in the eye. He was trying to get me. I saw him swing at me several times. Wouldn't that make more sense if he was trying to lie about this instead of I saw his hands coming at me and then I felt pain and I don't know, fingernails or what? Arliss Anderson, who doesn't have anything against him. You didn't hear one thing about. Don't listen to his wanderings and meanderings. Hold him responsible for what he did that day. Then you can talk about punishment later on. You can adjust it however you think it is. But don't let him just walk away from this. You know what that does? That tells him, you know what? Go do it again. Throw all the fits you want, do what you want, then come in here and just go, oh, they're all against me, and everybody just let him go. Go ahead, let him go. If you want him to do this again and just keep on doing this, let him go. Feel sorry for him. Or you can say, you know what, enough's enough. You don't rule this world. You don't get to rule the jail. You don't get to rule this day, and you don't get to rule this court, no matter how hard you try. Hold him responsible. Find him guilty, and then let's get on to the next part, and you can do what you need to do there. Thank you.
All right. Ladies and gentlemen of the jury, this time I'm tendering the jury charge to the bailiff. I'm going to ask you, please step down from the jury, follow the bailiff into the deliberation room. We will await your verdict.
30 minutes later.
And the record shall show that the jury is in the courtroom. All parties are present. And you, sir, are going to be, your name, I'm sorry.
Dallas Stanley.
Okay, stand by. Yeah, you're juror number 28 on this. You are the foreperson of the jury. We have received a message on behalf of the jury that the jury has reached a verdict in this case. Is that true, sir?
Yes, sir.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury?
Yes, sir.
Do any of the jurors, fellow jurors, disagree with your foreman's representations? No disagreement is indicated. It does appear to be unanimous. I'm going to ask you pass the documents to the bailiff. I'm going to review for proper form, and I will publish the verdict. And in cause number 23, the defendant shall rise, please. In cause number 23, CR 727, we, the jury, find the defendant guilty of the offense of aggravated assault against the public servant as charged in the indictment, signed by the jury foreperson. And this again is 23 CR 727, the state of Texas versus Raymond Peoples. The jury verdict is received. It is made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time I have received and accepted your verdict finding the defendant guilty of the offense as charged in the indictment. That brings us to a close of phase one of this two-phase trial. We will be proceeding with the punishment phase next. And let me repeat once again, you still are under all instructions previously given to you. Is the state and the defendant ready to move forward with the punishment phase of this trial, state?
Yeah.
And Mr. Peoples?
Yeah.
All right. The state, you have, there is a second paragraph in this indictment, ladies and gentlemen. And at this time, I'm going to ask the state of Texas to read and make a formal statement of this second paragraph of the indictment. Go ahead.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term that before the commission of the primary offense, the defendant was finally convicted of the felony of aggravated assault, second degree, on April 22nd, 2021, in cause number 16-24808, in the Criminal District Court of Jefferson County, Texas.
And that is signed by the foreman of the
Yes, sir.
grand jury. Raymond Peoples, you have just heard the reading of paragraph 2 of this indictment, which states that you were finally convicted of aggravated assault on April 22nd, 2021 in this Criminal District Court of Jefferson County, Texas, in cause number 16-24808. Is that allegation true or untrue, sir?
The fact that you have no jurisdiction is not true.
All right, untrue will be entered into the record on your behalf. All right, the state of Texas?
Yes, sir. Contender States 39 and 40, Judge.
Okay.
Any objections?
No.
Sir? Any objections?
I told him no.
You said no. All right, without objection, states exhibits 39 and 40 are admitted.
So let's look at States Exhibit 39. And if you have to, I'll blow it up for you. I'm gonna blow it up pretty good. This is cause number what?
16-24809,
And it's the state of Texas versus who?
Raymond Peoples.
And what is the charge?
Attempt to take a weapon from an officer.
And the offense date?
Was 3/29/16.
And what type of felony is this? What degree is it?
This state jail felony. Mr. Lurk, could you go back one?
Sure.
So 3/19/16. Yes, okay.
So it's a state jail felony, is that correct?
Yes, sir.
And it says this was a plea to a motion to adjudicate. Is that true?
That is correct.
And is that that's a revocation of probation, is that right?
Yes, sir.
And does it say underneath that he pled true to 2 counts under that 3 and 6?
Yes, sir.
And that he pled not true to 7, 8, and 9, is that correct?
Correct.
And what does it say that the confinement was, the punishment was for this?
2 years in state jail division.
And what date up here was this date of this sentence imposed?
4/22/2021.
So the weapon he attempted to take from the officer was a firearm, is that correct?
That's correct.
And just to make sure we know, on the part of this is when we do plea papers, do they also have to sign what they call a judicial confession?
They do.
And down here where it says, I have read, can you read what that says?
Yeah, I have read the charging instrument and my attorney has explained to me and I have committed each and every element alleged.
And does it say down here under this that they swear to that? And
Signed by Raymond Peoples.
Okay. So he signed a judicial confession saying he was guilty of that offense, am I right?
Yes, sir.
Okay. Now let's look at State's Exhibit 40. What cause number is this?
16-24808,
And is it state of Texas versus who?
Raymond Peoples.
And what type of charge is this?
An aggravated assault,
And the date of the offense?
3/29/2016.
That the same.
Troy Robinson.
Sure, Mr. Robinson. So the day, did you recognize?
Those 3 words right there, that's in the middle of the screen. Do you know, can you read? I'm reading that a lot. Judgment adjudicating guilt. Do you know what that means? Judgment adjudicating guilt.
Yes, you're guilty.
Now, deferred. When they say deferred, right? He don't have that paper. But if you put the word deferred right there, what would it be?
To be deferred.
Well, like what do that word?
If I guess in a situation, hypothetically, if you were put on deferred probation and you completed your probation without violating it, the sentence will be deferred and you wouldn't be considered guilty of it.
So, in other words, the day that I signed and agreed to this, right? Deferred adjudication, probation, right? It's probation that he's saying, I pled true. You see how you pointed to this and said I pled true. Those counts was because I was on probation, correct?
That would be correct.
So,
I'm not sure what for, but
right. Well, attempt to take weapon from her. But the thing about it is, the fact that I was on probation and if they said deferred adjudicated probation, right, that would mean a delayed judgment, correct?
I can see what you're saying, but I'm not familiar with the facts of these cases, so
Well, I'm not
I don't know
asking,
your history other than what I've been presented.
well, I'm not exactly asking about the fact.
Well, I'm not an attorney either.
Oh, okay, so there we go. So just for a little education, deferred means delayed, right? Adjudication means judge, pronouncing a judgment, right? Probation, well, we know what probation means. So which means the day I sign a probation on a probation like this, deferred adjudicate, which means I wasn't found guilty that day. You ever heard of that kind of?
I mean, you're asking me or you're telling me?
I'm asking you, have you ever heard of if a person signed for deferred adjudicated probation that and the judge agreed and announced it, right? Do you remember? I mean, have you ever heard of it not being a judgment until that person is violated?
That's a little bit out of my wheelhouse. So I was, the whole dynamics of that.
So how do you understand?
I'm familiar with judgments, reading them, going over what the person was convicted of, and processing the print from the person, you compare it to the person.
But you don't understand the difference in the kind of judgments. You just know it's a
Well,
judgment.
no, I mean, I understand what they're asking,
You do?
but I mean, I'm not sure what question you want me to answer.
Do you know what deferred adjudicated probation is?
Yes. I
So-
explained that a second ago.
Right. That's why I'm not understanding why you said you don't
Well,
understand.
I'm not sure what question you're asking. You had like a 4-part question there.
Okay, I signed the day I signed that you said he just showed you my signature,
Correct.
signed for, and the day the judge agreed to, right, and
Okay.
established that I signed.
It's no longer deferred at that point. So
It's not.
No.
So what do
you were convicted of it.
I was convicted that day?
Correct. The date that's on there, I think it's, I'd have to see the judgment, but I think it's on the right-hand side. It's for, no,
Yeah, look at the other way.
other way.
Other way? Oh yeah, right here.
No, right-hand side. Oh, yeah. Date of sentence, 4/22 of 2021.
So that was the day I was sentenced, right? Judge, that was the day of judgment, right?
Yes.
Do you, that paper that you just had on my signature, where is it?
Sit there. You see, it's
That was it, that's the same
part of the
thing?
exhibit. Towards the back.
So my signature is on this paper. Do you know what that means right there?
Your signature's on that paper?
Right, like this is the start. The fact of, do you know what it means for this sentence to have that date?
Yeah, that's the original, community service, supervision order. The
Right,
day you were placed on probation.
that was the day I signed, right?
For probation, correct?
Right. So if the day that I was judged is right here, and the day that I signed is different, how was I found guilty on the day that I signed?
So what you have here is you're just, showing us one piece of paper. The whole packet, which you guys will be able to look through, is considered, like, it's a court packet, right? It's gonna be a certified copy from the district clerk's office. It's kept in their regular course of business. We get the certified copy, which is gonna have all the information in it, along with his fingerprint that, the attorney directs to use. So I mean, there's several more pieces of paper there's probably like 10 or 12 pieces there for that one package that will explain all of it.
We don't shoot both of those into this interview just quick. Perfect. So when I asked you earlier, you said the day that I signed was the day I was found guilty, correct?
I would need to see the piece of paper you're talking about.
No, earlier when I asked you, you said the day that I signed, that I pled guilty was the day I was found guilty, correct?
So I wasn't here for your signature. In regular court, what would happen is when they sign, where there's like for instance, 4/22/21, is when he was convicted, he would have to sign, give his fingerprint to the clerk, and it would go from there, and the conviction would be filed, over at the district clerk's office. Which is pretty much the same thing, if I'm not mistaken, that they do for when they're put on, probation. They would receive probation with the judge, they would go next to the clerk, they would signature fingerprint, and they would go on.
So are you explaining that I signed something April 22nd, 2021?
I wasn't here for you to sign it, but in the document, you have your signatures there.
But that's absolutely not true. When the judge found me guilty, I walked out this courtroom without signing nothing at all that day.
I would have to defer to the attorney or the judge on that, I wasn't here for that.
Is that correct, Mr. Lynn?
What, you didn't sign for anything?
Did I sign something that day?
I don't think you signed anything that day, it doesn't matter.
No. Well, it absolutely matter because you said you understood this, correct?
I do understand.
And you did earlier when I asked you the day that I signed, was that the day I was found guilty?
And I said this, I would have to see the piece of paper.
So you didn't say that, yes, that was the day he was found guilty. You didn't say that.
Okay,
I'm asking, did you say it?
I would have to have it very back.
No, I'm talking about, or you forgot?
You've asked me a lot of questions.
I called him for fingerprints and to compare it to the judgment. I just had him read off the judgment. If he wants him to read off of it instead of explaining it, I don't have any objections. Otherwise, he's gonna keep asking the same question, get the same
No,
answer.
I'm trying to get him.
I object
Question.
to just being outside of this witness's expertise.
I'm trying to get him to answer the question from his understanding.
He can answer if he's able to, under what part he played in the review of these items.
Right, that's why I'm asking, do you, earlier when I was asking you, do you remember saying that the day that I signed is the day I was found guilty?
So that judgment was completed on 4/22/21, correct?
Yes.
Okay, that paperwork was filed for that date. And all the information in there is certified for that date of sentence commuted. So I was not here for your signature. I did not see you sign it. I'm telling you, it's in the packet.
But do you understand my question?
What is your question?
Earlier when I first asked, the day that I signed for probation, is that the day I was found guilty? And you said, yes, that is the day you was found guilty. Do you, I'm
I don't
asking
recall
you.
you asking it that way.
Judge, the state of Texas will stipulate that the day he signed for probation was deferred probation and he was not found guilty at that time. He was found guilty on April 22nd, 2021.
That's the law.
All right, then now I'm getting somewhere, which means that I wasn't found guilty on the day I signed for probation. So why did you go through all this and present it as if I was found guilty under my signature?
Are you questioning him?
Actually,
No, you're questioning this witness, not Mr. Laird.
Oh, okay, you're right. So
Come on.
why is it y'all went through all of this as if I was? You just can't fingerprint me, and you trying to add. And you said you compared it to the day I was found guilty, right? And you, because I guess y'all doing this because I said, I don't agree to the priors and all of that. I'm assuming that's why y'all went through all this.
On paragraph 2, the aggravated assault conviction on April 22nd, 2021 is alleged in paragraph 2 of the indictment, which comes into play for sentencing purposes. We read that. I read it. You pleaded untrue.
Right.
Then the state, to prove that up, did what they had to present evidence that you were placed on probation at one time, and then that probation was deferred or unadjudicated probation. It was revoked, and the court sentenced you subsequently on that date. And that's to prove up what is alleged in paragraph 2.
Right. So I said the judgment is not true or whatnot. And you said it is true because I signed it on that day, right?
What's your question?
What is the point of it?
This is
I'm gonna object.
Yeah, sustained. That's.
Yeah, I am.
The jury is listening to the evidence and they'll decide how much weight and credibility
Okay,
to give to it.
I'm gonna move
You
on.
don't make an editorial comment, just ask questions. So, but under the rules of law, when somebody is placed on deferred or unadjudicated probation, that is a kind of a newer type of law that came into effect, which is a good thing. The old traditional probation, you were found guilty, sentenced, and your confinement was suspended, but you were convicted. And so a conviction has its difficulties on people. So subsequent to that, the legislature came up with what's called deferred or unadjudicated probation. A jury cannot give deferred probation. They can only give regular probation. But if a defendant pleads guilty to the court, then if it's agreed upon by the parties, then the court can defer any finding of guilt. And they're put on terms of probation which are similar to regular probation terms. Don't commit crimes. And there's 34, 35 conditions. And most of all those conditions are the same conditions you and I have to do every day. But if on deferred probation, they're not found guilty unless during the course of probation, they commit violations of their probation, then a motion to revoke probation can be filed by the state of Texas. And then that is heard by the court. If the court finds by a preponderance of the evidence or greater, which is the same test in a civil court on a motion to revoke probation, it's less than beyond a reasonable doubt. If a court deems that it's been proven while on probation, they failed to follow the terms of probation, then the court can revoke probation and sentence them to the full range of punishment that they were subject to. They, by that point, are found guilty and sentenced. And that is the way a deferred or unadjudicated probation works from beginning through the process. If a motion to revoke probation is filed and then it's revoked and sentenced. This court's, I'm just going to editorial opinion. 93% of my probationers are successful. The average is about 75% for the country, and we have a 93% success rate in this county. So I'm very proud of our probation office in the way they handle probationers and escorting them through probation. But that's the way generally a probation works when we have what's called deferred or unadjudicated probation. Okay, go forward.
I'm sorry for the broad question. I'm gonna make it, I'm gonna ask you a more substantial question. A second ago, District Attorney Mike Laird confirmed that was my signature. And you confirmed to him that was my signature, correct?
on which document?
On this document that we're looking at.
What states exhibit is that?
States Exhibit 39.
Do you need to see it?
Yes, I would like
Yeah,
to.
I'm going to ask the bailiff. Hold on. Let the bailiff, if you'd be so kind, pass that document to the witness so he can review. Thank you, sir.
Question, sir?
Did you confirm with the state that was my signature on that document?
Yes, on States Exhibit 39, clause number 16-24809, on the very last page, in which I read earlier, when speaking with Mr. Laird, is your signature along with your thumbprint at the bottom that I use for comparison.
Was that to prove the judgment of that document?
There's actually more than one fingerprint on this. Used every fingerprint that is here. There's also a fingerprint on page 4 of this document as well. And so both fingerprints were compared, and they compared to your fingerprint on State's Exhibit 41
What was that to prove? What was it to prove that that judgment on that document?
That was to prove that the same person on the fingerprint card, you, Brandon Peoples, is the same person who put their fingerprint on this judgment.
That's
State
all.
Exhibit 39.
That's
That's
all.
it.
That's all.
Yes, sir.
Okay. No further questions?
Anything else?
No,
Is this man excused?
please, Judge.
You are excused.
And Judge,
Next, please.
Rest, Judge.
State rests. Mr. Peoples, anything you want to present for punishment purposes?
Yeah.
Can you think of anything you'd like to present to the jury that help them? Because on the punishment, it's about character. Did you want to make a summary of what you want to tell them about you?
No.
Okay. No. Ladies and gentlemen, the parties have rested. I have a proposed jury charge that I need to review. I know you'd like to move forward, but it's going to take, the parties get to review it, and if there are any changes, I've got to make the changes. It's going to take probably 15 minutes or so for everybody to look at it, depending upon how fast they want to read through this. And then if there's no objections, then I can read the jury charge and y'all can go and deliberate. If there are some changes, y'all got to bear with me to make the changes. What do you want to do? I'm going to do what the jury wishes. It looked like we had about a half on one side, half on the other. Does anybody, let me ask you this, does somebody have a time problem that you need to get to this evening that you just can't stay a little later? If you do, let me know, because you do, ma'am. All right. Well, that carries with everybody. If it's just one, and that's okay. Yeah, but no, but an alternate, I've included alternates during deliberations. We've lost jurors during deliberations, sir. That's the way it is. It's just the way they have to be present to listen to the arguments and to make a decision. And it is the court's decision on the timing. Ladies and gentlemen, if one person can't make it.
Please don't make me.
No, I'm sorry, you don't run things, sir. If one is released, there's always a chance we could have a problem. That if two people couldn't serve out for some reason, and it has happened, then without the alternates, then we are mistried, and that's not going to happen. That mistrial means you have to start all over again. We don't want that. I'm going to ask you to return back at 9:30. Please remember the instructions the court has given to you, and this, it's people generally.
People do not want to convict. I don't want to convict.
I'm sorry, but we work generally until 5, but when there's a problem, all the jurors have to be available, and it's a regular work hour until 5. So are you sure? Okay, y'all want to stay and get this accomplished? Is anybody else? Okay, it looks like everybody's with us. All right. We're going to take a short break while they look at it for a few minutes. And if it's fine, I'll read the charge, then you'll go and deliberate. Okay. All right. Thank you, ma'am, for working with us. All right. Ladies and gentlemen of the jury, at this time, I'm going to read to you the jury charge for the punishment phase of this trial. And again, please continue to observe the instructions previously given to you. As before, this charge will be left with the jury and your foreperson, so you can refer to as necessary during your deliberations. Members of the jury, you have found the defendant guilty of the offense of aggravated assault against public servant as alleged in paragraph 1 of the indictment. Paragraph 2 of the indictment further alleges that the defendant was previously convicted on or about April 22nd, 2021 in cause number 16-24808 for the offense of aggravated assault in the Criminal District Court of Jefferson County, Texas, and that this conviction had become final prior to the commission of the offense for which you have now found him guilty,
as indicted, the first-degree felony of aggravated assault against public servant. Your verdict as before must be unanimous. Your failure to follow the law contained in this charge could result in a mistrial being declared, and your deliberate violation of these instructions could result in your being held in contempt of court. We have two sets of jury instructions, and each of them have 4 hours to review and determine which is applicable based upon your decision on the prior conviction, whether that's been proved or not. Only one option of the 4 on either set can be signed. Does everybody understand? Everybody understand your 4 options here? And the next set are based upon whether, if you believe that the state has not proven beyond a reasonable doubt that the defendant was previously convicted.
They have.
Sir, you just made an outburst. Again, an inappropriate outburst. Please don't do that again, sir. Thank you. These 4, again, we will go over them, ladies and gentlemen. The first option of these four, we the jury find the defendant has not been convicted of any previous felony offenses as alleged in the indictment and assess his punishment at confinement in prison for a term of blank years, no less than 5 nor more than 99. Does everybody understand the distinction here? Place for the 4-person sign. Second option, we the jury find that the defendant has not been convicted of any previous felony offenses as alleged in the indictment and assess his punishment at confinement in prison for a term of blank years, no less than 5 no more than 99. In addition to such imprisonment, we assess a fine of not to exceed $10,000. Everybody sees the difference there. A fine is applied on this one if that's your choice. The third option, we the jury find that the defendant has not been convicted of any previous felony offenses as alleged in the indictment and assess his punishment at confinement in prison for life. And your final option, we the jury find the defendant has not been convicted of any previous felony offenses as alleged in the indictment and assess his punishment at confinement in prison for life. In addition to such imprisonment, we assess a fine of blank $9. Only one verdict form can be signed out of these 8. Does everybody understand the distinctions? All right. As before, the state of Texas may open and close final arguments. What says the state?
Once again, Judge will waive a right to open reserve right.
You may. Mr. Keeples, you may present your argument to the jury.
Wait, my wife. You waited for it.
All right. You're doing that voluntarily and because that's what you want.
That's what I want.
Oh, then the state may go forward.
I'll be brief since we don't have, we're after hours here. I think it's pretty obvious when you look, and you can even take these back with you if you want to. The allegation alleged in the indictment states he did it number 40. You need to look at it, which is the actual assault, which was the actual conviction occurred before he committed this offense and was convicted of it. So makes it 15 to life, and that's what we're asking you for. And I think you need to, I feel really bad because whatever I ask you to do, I'm going to put you back. I'm going to put him back with those jailers. They have to put up with him. But he talks about the fact that, well, first of all, he says he does so well in prison that that's where he doesn't commit any other of these offenses, that he says he does well and he's out in free population. So you're actually doing him a favor of getting him out of isolation and putting him in prison. And I hate to say that, but because it is punishment. And I'm asking you this because I want you to think about this. First of all, he's right. He was placed on probation, I'll just do it this way. He was placed on probation. And if you look at this, you'll see that back here on the signatures is not only the Raymond Peoples signature, but my signature. I gave him a chance. Back in 2016, I gave him a chance. I said, if you'll own up to this and you behave yourself, you can get out of this without a conviction. You get probation for 10 years. And if you're really good, you can get off probation without a conviction. He couldn't follow the rules. And that seems to be a pattern with Mr. Peoples. He doesn't want to follow rules. He wants to control everybody. That's what he wants to do.
Because you said.
Sir,
He wants to control everybody.
I'm sorry. Hold it.
So
Sir, you cannot make outbursts. You gave up your opportunity to make a final argument. He has a right under the law without interruption to make his final argument. So please follow the rules, sir.
But
Go
you can't.
ahead.
He cannot follow rules. And the problem is with this is that it's kind of funny when he does it in here. But when he does it in a jail setting where there's weapons, or he's got things that he can hurt people with, or where he throws feces on them or does things to them to just totally make everybody's life miserable. Plus he's got other inmates that he's throwing things on. He's trying to escape. He's doing all these different things. It's not funny. This time it's not so funny is because he's facing 15 to life and it's serious. And yet he's still here making all these comments because to him, it's just a game. Everything is a game. It's not about anything but control. It's all about Mr. Peoples. So what I'm going to ask you to do is I'm going to ask you to make this sting, because he was serving a 20-year sentence when he did this, and evidently that doesn't scare him one little bit to serve a 20-year sentence. He's asked you all ago, he told you just go ahead and give me a life to send me home, and that's up to you. But I'm asking.
That's what it is. I'm telling
I'm sorry,
you, I'm arrested.
sir. The second time I've had to scold you on making outbursts during a time that he is not to be interrupted by law, just like you were not to be interrupted if you wanted to make your closing argument. Please follow the rules. Again, I state to you, please follow the rules.
And it makes me sad that an individual can't just do what he's asked to do. I mean, it's real simple. Just move here, do this, just remain quiet, follow the rules. But he has to be in control. And we talked about that in board hour. People have to be in control, and he's got to be in control being his own lawyer. He's got to be in control in this courtroom by stopping and saying, and I let him have his free reign. Y'all saw that I did that. When he got up there and said, I let him have his say. And I wanted him to have his say. I wanted him to be able to tell you everything he wanted to tell you, because you realize who he is.
Because you had already convicted you.
Sir, this is the third time during the final argument you have interrupted the attorney. And again, do not do that.
So y'all go back there. You know that enhancement's been proven. So following your oath, you find it true. And the first 4 pages that you see of their verdicts is what you're going to be looking. And you're going to ask me to give you something. I'm just going to ask you to give him a really good bump up from 20 years because of the fact that he was serving 20 when he did this. And that doesn't seem to affect him. So he needs to get a little spanked a little bit harder to make sure that he understands that he's not in control. He is
Sir,
not in control.
for the record, that's the fourth time that the defendant has defied the court's order and has interrupted the prosecution, who is giving his final closing, which the law says he can do without interruptions, unless you want to make a legal objection.
That was a legal objection.
That was not, sir.
Objection for pointing the gun,
Proceed.
30 years to life.
Sir, your objection's overruled. Proceed.
See, the problem is you wake up every morning and you see violence out on the street. And so what do? We put them in jail. And we trust them to people that they come up here and they try to do their best to watch these people. And what does he do? He creates the violence in the jail. You can't seem to stop him from doing that. So there's only one place to go, and that is someplace where he's going to be controlled by some state people that will have more resources than our county jail to keep him there, to keep him under control. So I'm asking you to at least double what he got before, from 20 to 40, to make sure he knows that this is not the right thing to do, to treat people the way he treats people, and he's not in control. Thank you for your time.
And ladies and gentlemen of the jury, this time, I'm tendering the jury charge to the bailiff. I ask you to please follow your foreperson into the jury deliberation room. We will await your verdict. And alternates, thank you for hanging in there with us.
If y'all feed up this man sleep at night, and get life in prison.
Sir, you're going to have to muffle him. He can't be speaking to the jury as they're leaving like that. That's improper.
30 minutes later.
And the record shall show
that the jury is seated in the courtroom. And Mr. Stanley, as foreperson of the jury, we've received a message on your behalf stating that the jury has reached a verdict in this punishment phase of this case involving Raymond Peoples and cause number 23 CR 727. Is all of that correct, sir?
Yes.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury?
Yes.
Any of the jurors disagree with your foreperson's representations? No disagreement is indicated, and it does indeed appear to be unanimous. As before, if you would pass the documents to the bailiff, I will review the proper form and publish the verdict. But you only one assigned, and y'all did that right. All right, the defendant shall rise. In cause number, the defendant is refusing to rise, for the record. In cause number 23 CR 727, the state of Texas versus Raymond Peoples, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment, and assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 40 years. Signed by the jury foreperson. The verdict is received and made a part of the record for all purposes. All right, in 23 CR 727, is there any reason, legal reason, why judgment shall not be formally assessed at this time?
No, Your Honor.
State or defense? No response from Mr. Peoples. Mr. Peoples, Raymond Peoples, you can and a jury entered a plea of not guilty to the offense as set out in the indictment. The evidence was submitted. The jury was charged by the court. After deliberating, the jury returned a verdict finding you guilty of the first-degree felony of aggravated assault against a public servant. Thereafter, evidence was presented on the punishment phase. The jury was instructed on the law on punishment during their deliberations. After deliberations, they assessed punishment at 40 years confinement in prison. It is therefore the judgment of this court that you are guilty in this cause number 23 CR 727, and you shall be punished in accordance with the jury's verdict. Is there any legal reason why sentence should not be pronounced against the defendant by either party?
No, Your Honor.
Finding nothing to bar the pronouncement of sentence against you, it is the order of the court that you, Raymond Peoples, who has been adjudged to be guilty of the offense of first-degree felony of aggravated assault against a public servant in this cause number 23 CR 727, and whose punishment has been assessed at 40 years confinement in prison in the Texas Department of Criminal Justice's Institutional Division, shall be delivered by the Sheriff of Jefferson County, Texas, to the Director of the Texas Department of Criminal Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined for 40 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. Under Article 42.08 of the Texas Code of Criminal Procedure, the law states if a defendant is sentenced for an offense committed while the defendant was an inmate in the Texas Department of Criminal Justice and serving a sentence for an offense other than a state jail felony, and the defendant has not completed the sentence he was serving at the time of the offense, the judge shall order the sentence for the subsequent offense to commence immediately on the completion of the sentence of the original offense. What does the state say?
Judge, it's pretty clear that this person was, Mr. Peoples was serving a 20-year sentence and was still under the custody of the Texas Department of Criminal Justice. So it's mandatory to be stacked. We'd ask that you stack it on top of this prior sentence in cause number 16-24808.
All right. Your objection
is made, it is overruled. The law is clear
No, y'all.
under Article 42.08.
Completely.
So you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. And that sentence of 40 years shall commence immediately on the completion of the sentence. For
3 years.
You're going to have to stop him from speaking so we can complete this. As obstreperous as he'd been through the whole trial, he continues to interrupt the court. The judge, under the law, orders, and this is cause number 16-24808.
That's correct.
That the court finds that the defendant was an inmate in the Texas Department of Criminal Justice serving a sentence for the offense of aggravated assault, a second-degree felony, convicted on April 22nd, 2021, in cause number 16-24808 in a conviction in this criminal district court of Jefferson County, Texas. He has not completed the sentence he was serving at the time of the offense that he has now been convicted, this first-degree felony of aggravated assault against a public servant as adjudged by the jury. Thus, the judge is ordered to sentence the defendant of this subsequent offense. He has now been found guilty in 727, which was committed subsequent to the conviction he received in cause number 16-24808 of the second-degree felony of aggravated assault. The judgment shall state that this offense here, the sentence in 23 CR 727 of 40 years confinement in prison, shall commence immediately on the completion of the sentence the defendant is serving in cause number 16-24808, the aggravated assault second-degree felony. And thus, this sentences shall run cumulative or consecutively to each other by law. The defendant will be given credit for all time he has served in accordance with these sentences. And that is the finding of the court, and that is the ruling. Anything else to add, state or defense? We're in recess. You are here. You are now remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of this sentence. That is all. And please note that the defendant was shouting over the court as he is being led out, as the court is trying to read the formal sentencing and a judgment as provided by law. And again, throughout the trial, the defendant interrupted, refused to follow orders of the court in proper so that the proper order of the proceedings could be made. His attempts throughout this trial to interrupt and were allowed for the most part by the court, although the court would attempt to instruct him not to do that. That never stopped him to the very end as he continued to interrupt the court. And also his defiance to court rulings throughout this trial also were multiple, as it's obvious that the defendant was not about to follow the rule of law nor the orders of the court. The court attempted, though, to give him more leeway than the court has given to any other defendant
out of the court's history of 616 jury trials in this courtroom. But nonetheless, the defendant to the very end acted obstreperous and defiant of the rulings and orders of the court, and interrupted throughout the proceedings. And this court even allowed him to make lengthy narrative statements during his presentation of the evidence, which were not in a question and answer method to a witness, but were his long narrative complaints about the processes that he was claiming to endure while being an inmate. All of that is clear in the record, and the court was attempted numerous times to allow the defendant chance after chance to correct himself, and to the very end, he continued to interrupt, defy court's rulings, respond in defiance to the court's rulings, and thus this was a case that had a lot of interruptions to it. All right. And all due to Mr. Peebles' defiance to orders and rulings, and defiance to just decent standards of respect to other parties and to each of the participants in the trial. And we are now in recess.
Yep. No, this song is not AI. The chat's asking me if this song's AI. No, this is Late Night Blue by Roots and Recognition, I believe, from Epidemic Sound. It's just one of the little bills I pay to keep this channel kind of interesting. I actually pay for the rights to be able to use this music and the music I use it again sometimes. And I absolutely do from time to time make some funny AI songs here and there. I'm not going to lie. But there you go, ladies and gentlemen. That is how the cookie crumbles for the idiot who attacked the correctional officers with pens and earned himself 40 more years in the pen. Yep, that's how the cookie crumbles. So he was already doing 20. He's looking at being on parole in 29. That's not going to happen anymore now. He's already doing 20, which will be up in 39. Now he gets to add another 40 on top of that. So let's see, it'll be 79, 20, 79 before he's so he's got man, I don't think I'll even be alive. I would be over 100 years old when he got out of jail if he did every minute of the time. Oh dear God. I'm tired. I want to go to bed. Ladies and gentlemen, thank you so very much for hanging out with me tonight. I am your lone wolf Oosel. I'm the guy who puts these crazy videos together, and I appreciate each and every one of you. And I have a lot of thank yous to say. So let's get it on the road, shall we? Thank you very much, all my great friends. Darth Steven, Fat Boy is back. Wendy, Greek, Darth Steven again. Fat Boy is back again. Specs, Darth Steven, Specs, Tracy, Fat Boy is back. Unbiased Jurist, Darth Steven, Spec. Oh my God. Just all the super chats. We got a cup of coffee for Mama in there somewhere. It's, you know, ridiculously early stream has assembled and has concluded. Thank you all so very much. Mwah and love. Great love to all of you, especially Specs out there, who's been just giving and giving and giving all night long. Thank you, Specs. Thank you, Specs, and Specs again. Oh, wait. Did you want me to stop saying Specs? Oh, sorry about that. Sorry, Specs. You would think I might be doing it on purpose now, right, Tracy? All right, kids. It's been a long weekend. It's been a long week. We got a lot more to come. There will be something tomorrow, but I'm going to keep it for a surprise. Tune in to see what it will be. It will be at the same Wolf time, same Wolf channel. Thank you so very much, Darth. You are amazing. I will see you all next time. I'm your Lone Wolf Boostle, and I am out. Same Wolf time. It's 8 p.m. Central. Same Wolf time. And remember, only you can take a bite out of crime. Bye.